Hello, my name is Indah Melindasari and I'm registered migration agent from Wonderland Consulting. To keep up to date on all the latest immigration news and helpful visa information, please subscribe to our channel by clicking on the logo in the right-hand corner and click subscribe. Today we will be discussing the partner visa streams in Australia in detail. Partner visa application can be a very long and complicated process. It is not just about being in a committed relationship, you have to also gather detailed evidence over the years to prove every aspect of that relationship is real. And this is what you are asked to do by the Department of Home Affairs. It will be on you and your partner to provide evidence that you are planning to get married and you are already in a married or de facto relationship. There is no discrimination regarding the nature of the relationship, whether it is same-sex or not, as long as it is committed and genuine. There are several different options and pathways when it comes to partner visa. As with most Australian visas, there's a difference between offshore and onshore lodgement of applications. The specific visa you need depends on the nature of your relationship. If you are in a relationship and plan on getting married, you will be looking to apply for the Prospective marriage visa, the subclass 300, or sometimes known as the fiancé visa. If you and your partner have been living together in a de facto committed relationship or married overseas, then you will be looking to apply for the temporary partner visa, the subclass 309 or subclass 820. Your situation may be that you are an Australian citizen or permanent resident or eligible New Zealand citizen and you are living and working in Australia while your partner is residing overseas. While living apart, this will be scrutinized by the department and valid reasons must be given if this is the case. Let's discuss these visas in more detail. The first visa subclass that I will explain is the visa subclass 300. The Prospective marriage visa, the subclass 300 visa, is meant for those that are planning to get married in Australia. Once the visa is granted, you will have 9-month time frame in which you have to marry your partner. After the visa is granted, you must enter Australia before the visa expired in 9 months' time and marry your prospective spouse before the visa period ends. Once you have been granted the 300 visa, you will be allowed to enter Australia before you marry your prospective spouse, leave and re-enter Australia as many as you can, work, study, apply for a partner visa in Australia after you marry prospective spouse and stay in Australia for 9 months. However, you will not have access to the National Healthcare Scheme or Medicare. The visa will cost around 7,715 Australian dollars as of this year, plus other additional charges. The best news is that you will be able to live with your partner in Australia, and this is an ideal solution for couples living apart, as long as you have the intention to get married. This visa generally will take less time to process than the de facto relationship and marriage visa, and you do not have to show that you have been living together. Given the current travel restriction as well due to the COVID-19 pandemic, it is much more likely that you have been living apart as a couple, or that you or your partner had to stay in Australia for work reasons, which does not to be explained for the 300 visa. Once the marriage has been made official within the 9 months period, then you will be allowed to lodge an application for the partner visa from within Australia. In the interim period that you are waiting for your partner visa to be granted, which can take up to 20 months, you will be granted a bridging visa. This visa will be a placeholder between when your prospective marriage visa 300 expires and when your partner visa is approved. Note that this does not mean that you will automatically be granted the partner visa itself. It will allow you to legally live and work while the visa is in process, and it will allow you to access Medicare. For partner visa on the basis of marriage or de facto, we will be looking at temporary partner visa, the subclass 309, which is an offshore application, and the subclass temporary partner visa 820, which is the onshore option. Each visa involves two processes. that leads to permanent residency. For some cases, if you have been in a long-term genuine relationship and you can provide the evidence of it, you might be granted for a direct permanent residency. However, for couples that are in a long-distance relationship, this is often a hard requirement to meet. As such, generally people will follow through with the two-step processes that start with either the onshore 820 or the offshore 309. Both of these visas will allow you to live, work and study in Australia, enroll in the National Healthcare Program or Medicare, and enter and leave Australia as many times as you want. Both visas will come at the cost of 7,715 Australian dollars for the main applicant as of this year, and the processing time for the offshore is between 17 to 20 months, and possibly longer for the onshore visa. It's around 22 to 29 months, and this visa will remain indefinite until they have decided on your permanent residency. It will take 2 years, not from the date of your temporary visa was granted, but from the date you lodge your stage 1 application for you to be able to qualify for a permanent residency. And the Department of Home Affairs will again ask for the evidence that can be collected during the 2 years period to show that you are still in a genuine relationship, whether it is based on marriage or on a de facto relationship. It all depends on the current caseload that the immigration is handling, as well as seasonal peaks. Just be aware that the entire process from when you first lodge your first stage application to becoming a permanent resident could take as long as 3 years or more. In the case of the 820, being an onshore application, you might be transitioning from a working holiday visa or skilled worker, student visa, or maybe just even be a visitor visa. As long as you are living together under the definition of de facto or married relationship, you can then be eligible. It will be the same to your process to permanent residency as for the 309 offshore visa. The bridging visa will be granted when you are applying for the subclass 820 from a different visa onshore, whether you come to Australia on a prospective or on holding other temporary visa. And this bridging visa allows you to continue to live, work and stay in Australia while your partner visa is processing. The bridging visa A does not allow you to travel in and out of Australia, so you need to be aware that if you are on a bridging visa A while awaiting your partner visa onshore to process, you will need to apply for a bridging visa B, permission to travel. The bridging visa is there to bridge the gap in between the two visas you are transitioning between. For example, your 300 visa expired in 6 months, but your partner visa 820 will take 12 months to process, then the bridging visa will cover that time to allow you to stay legally in Australia. Even though the bridging visa is there, you must still follow the condition of your current visa. So if you're on a student visa, you still have to abide to the condition of continuing your study. Even though that you have lodged your partner visa, it doesn't mean that you can stop studying because the student visa is still valid. This will apply for a valid work visa as well. And if the condition of the work visa require you to work, then you must continue to do so. The breaching of these conditions could result in cancellation of the visa, and it may cause many problems with your partner visa or any future application. This is where the onshore process can get very complicated, and you should most likely get in contact with a registered migration agent like us at this point, so as not to risk you and your partner's future life together over what might be just a mistake or simple thing that you weren't even aware of. The judging of the relationship by the Department of Home Affairs is a subjective matter, as they can't feel the way you do about your partner, as we all know the nature of any given relationship is unique to that relationship. The only real guidelines is that relationship is genuine and continuing, which could really be understood in different ways. We do know that immigration does look into 4 main aspects when assessing a relationship, which they refer to as 4 pillars, which are financial aspect of your relationship, for example, joint ownership, joint loan agreement, bank account, evidence of pooling the resources from large financial commitment, and bank statements. And also social aspect of your relationship, for example, statement from family and friends, photos of the two of you out of social events, evidence of the joint involvement, charity groups, evidence of joint travels, and any commitment of plans for the future that can be evidence. The nature of the household, like for example, joint ownership of the property, leases or loan payments, joint utility bills, evidence of shared responsibility, taking care of children, taking care of pet together. And the nature of the commitment. So for example, how long you've been in the relationship, how long that you've been in a living together relationship, knowledge of your partner's personal information like family history, life story, personal interests and likes, and evidence of the intention of the relationship being long-term. Along with the evidence in the form of documents, such as a marriage certificate, bills, bank statement, ownership, deeds or property, you will also need to submit a status declaration in which you can clarify your personal aspect, how much you know about your partner, where, when, how you met them, and we have an accompanying video in the other series as well, going into more detail on how to organize and plan your evidence that you find a link to in the description. Some of these aspects can be evidenced through text messages and photos, social media, but the main point that they are looking for in these four aspects are that the relationship is, so genuine, continuing, have a mutual commitment, and partners are living together, not living apart permanently. And remember that the more you look like a couple in the photos, the better it is. So time to pull out all the lovely pictures of the two of you holding hands, sitting next together, hugging, and you also need to collect messages and calls to show your time frame or timeline of your relationship. There will be exceptions. For example, if you can provide evidence that due to the cultural or religious reasons, you and your partner could not publicly, express the nature of the relationship. And in terms of the de facto relationship, you need to show the nature of the relationship is essentially the same as you being married. Okay, so next one, you must also be sure to evidence that you have been living together for at least 12 months. And you will need to provide much more evidence to show that your relationship is valid. Okay, and there could be plenty of other things like you might not think at first, but it's all valid. At the end of the day, the hard evidence of documents will be the most convincing in your application. So make sure to keep any such evidence and be organized. There have been certain concessions in place as a response to the COVID-19 pandemic and the difficult situation applicants like yourself may be facing relating to the partner visa. And we have made a video which we explain this in further detail. Okay, and then I've tried to give you a detailed rundown on how it all works, but it is complicated and very long process. So maybe there was some information I missed out on or questions that you have that are still unanswered. It is a long, complicated and detailed process, and if you and your partner dream of being together in Australia, then don't risk the possibility of getting refused due to what it could be a small misunderstanding or mistakes in the application or submission of documents. Let us take care of your future by getting your application right and dealing with the details while you and your partner can make plans to build your dreams and live together in Australia. If you have any more questions about the partner visa or the process, Wonderland Consulting is here to help you with any questions you may have. We specialize in complex visa cases, and as a registered migration agent, we registered with the Migration Agent Registration Authority and regulated in our professional practice and bound by the profession's code of conduct. Take the first step and get in contact with us. We are experienced, trustworthy, and we seek to deliver results, and most importantly, we are here to help you. Thank you for watching. Subscribe to our channel or visit our website for the latest news and helpful information.